District Court 27 is now in session. Honorable Judge Allf presiding.
Thanks, everyone. Please be seated. Let me just get booted up here. Right. Let me call the case of Gruden versus the N.F.L. Appearances, please, starting first with the plaintiff.
Adam Hosmer-Henner, Jon Gruden on behalf of the Plaintiff, Jon Gruden.
Thank you.
Good morning, Your Honor. Maximilien Fetaz and Judicial District Court on behalf of the N.F.L. parties.
Thank you. This is your motion.
That's correct, Your Honor. And I know Your Honor has read the briefs even on this, shortened time frame, but after receiving Mr. Gruden's opposition, I think it's clear that we take some time and effort to reset the table a bit. The Nevada Supreme Court decision in Micon controls the issue here. And while I know Your Honor is very familiar with the fact that Nevada may sometimes not have controlling case law on all issues that come before Your Honor, and as practitioners we, at the Supreme Court's direction of course, present to Your Honor decisions from other jurisdictions for guidance. And it appears Mr. Gruden has done that here, citing cases from Washington and California and various federal circuits like the 5th and 7th Circuit. However, there is no need for that outside reliance here. We have the controlling standard that the Nevada Supreme Court set forth in Micon. And the court there very plainly stated that absent a strong showing that the appeal lacks merit or that irreparable harm will result if a stay is granted, a stay should issue to avoid defeating the object of an appeal from an order refusing to compel arbitration. And the Micon court further went on to say that an appeal only lacks merit where, and I quote, the appeal appears frivolous or the appellant filed the stay motion purely for dilatory purposes. Now, Mr. Gruden offers no Nevada authority to counter these standards or burdens. Instead, Mr. Gruden points to other states to counter the controlling Nevada authority here. But again, the Micon decision controls, and as the Micon decision sets forth, the first factor under NR AP 8 takes on added significance. That is, whether the object of the appeal would be defeated if the stay is not granted. And that, that added significance is with good reason. The bargain for benefits of arbitration would be lost if an appellant were forced to proceed and continue with judicial proceedings while the appeal is pending. And it is for this that, and that exact reason that the Nevada legislature enacted NRS 38.247 and provided for a direct interlocutory appeal for orders denying arbitration. Now, to be clear, the N.F.L. parties do not bear the burden to show a likelihood of success on the merits under the Micon decision. Under Micon, Mr. Gruden holds the burden to show that the appeal has no merit because, again, it is either frivolous or purely for dilatory purposes. Neither is the case here. And Mr. Gruden made no showing otherwise. Instead, he chose to relitigate the merits of the motion. And frankly, under Micon, we don't need to relitigate those merits again. We understand and respect that Your Honor made a ruling. And I know Your Honor understands, having been before you many times, that we will sometimes disagree on Your Honor's rulings. And it is nothing personal.
I take no offense at that.
Exactly, and I know you commonly let the parties know and counsel know that it's nothing personal. But as individuals in this profession, we understand that disagreements arise, and then we as practitioners avail our clients to those appellate rights and remedies. And clearly, we have not sought this appeal for any frivolous purpose or for any delay. We have sought this appeal and have submitted arguments in good faith and in the belief that they have merit on the appeal. Additionally, it is also Mr. Gruden's burden, not the N.F.L. parties, to show irreparable harm. In fact, Mr. Gruden is required to show that he would suffer irreparable harm if the stay is granted. Mr. Gruden merely offers that he might suffer some prejudice from a stay. That clearly doesn't meet the burden here. Simply put, Mr. Gruden did not and cannot meet his burden of showing that the NFL party's appeal is frivolous or purely for dilatory purposes, or that he would suffer some irreparable harm from a stay. So accordingly, the NFL parties would submit a request that the court grant the NFL party's motion to stay and stay these proceedings pending the appeal on the order denying arbitration. And with that, I'll reserve any time for rebuttal.
Thank you. Opposition?
Good afternoon, Your Honor. Again, Adam Hosmer-Henner for Plaintiff Jon Gruden. We did cite to NRAP 8C and MICON, and believe those are the controlling standards, but there's absolutely no authority from Nevada or from any other jurisdiction that was cited that places the burden on the non-movement to establish any sort of burden with respect to requesting a stay. The NRAP 8 and MICON establish 4 factors that the court should consider, and at all times, it's the moving party's burden to establish that those 4 factors, taken as a whole, weigh and support a stay. Obviously, there's not an automatic stay here, otherwise that would have been provided, and it's the court's obligation to weigh those factors, and although they're accorded different weights according to MICON, and determine whether a stay is warranted here. Now, the state of the law is such that in many cases, a stay is generally granted when an appeal is taken from an order granting a motion to compel arbitration, but not always. And even though we had a limited amount of time, the research that we did do and the 2 cases that we attached to our opposition showed that when a non-signatory is trying to use the principles of equitable estoppel to compel a stay, that in those instances, at least the 2 authorities that we found, and none were cited to the contrary by defendants, argue that against the granting of a stay. And what MICON says is that under the approach that it sets forward, a stay should be denied when arbitration is clearly not warranted, but a stay should generally be granted in other cases. And we agree with that, and we think for all of the reasons that we set forth in our briefing originally and at the hearing, that arbitration is clearly not warranted, especially here, where the factors are usually in the context, and you heard from opposing counsel, of a party getting the benefit of their bargain. These are not contracts or arbitration clauses that the N.F.L. or Commissioner Gruden bargained over with plaintiff. There was no consideration, no negotiation, no exchange of promises. So we haven't heard any articulation of here, in this case, what the object of the appeal actually is, what the benefits of arbitration actually are, or any other grounds that apply and are tailored to this case, other than to say that a stay should generally be granted in order to give a party the benefit of their bargain. I won't go through the specific factors that we analyzed in our opposition unless this court has those questions, but what I will say is I would like to adopt a very pragmatic approach to this under the standards of NRAP 8. And it's a little bit awkward, it's a little bit like a preliminary peek at the federal level, where a district court is then asked to immediately consider their own decision and determine whether there's a likelihood of success in the merits of the appeal, and then determine whether a party whether arbitration is not clearly warranted. This court found that all of the facts militate against granting a defendant's motion to compel arbitration, and for many reasons, any one of which is sufficient to deny their request to compel arbitration, this matter should stay before this court. We're here on an order shortening time where, at least in our opinion, defendants have advanced an incorrect understanding of the law with respect to the burdens that a party have on moving for a stay. If this court does enter a stay, that effectively ends our ability to contest that. If this court does not enter a stay under NRAP 8C, under NRAP 8, the defendants are required to first move in this court. But if this court does not enter a stay, they can then immediately go to the Nevada Supreme Court and have the Nevada Supreme Court address this issue. And that's why so many district judges in Nevada, after entering an arbitration order that's not close, deny the stay and leave it to the Nevada Supreme Court to determine that issue, because although procedurally they're required to first come here, there's no actual substantive or negative effect for them and then proceeding with the same request in front of the Nevada Supreme Court. Our representation, which is why we were a little bit confused as to why this was done on an emergency basis on an order shortening time, is that there is no current deadline for defendants to take any action in this case. if one does arise, we certainly are willing to stipulate that until the motion to stay at the Nevada Supreme Court is resolved, that defendants will have an extension of time to take any action in this course until they can proceed on that appellate remedy. But we don't see any reason after this court has ruled so strongly against arbitration that it would then stay these proceedings based on potentially incorrect standards advanced by defendants.
Thank you. Reply, please.
Just three points, Your Honor. Again, Mr. Gruden's counsel again got into the merits of the decision. And again, Your Honor, we're here not because we are quarreling with Your Honor's ruling that set forth. We're prepared to move forward in the case, and by doing that, we filed our appeal and are seeking to move forward. And under the Micon decision, we have advanced good faith arguments that we believe go towards our arguments that would be presented on appeal, and they are not for any dilatory or frivolous nature. And again, that is the standard set forth in Micon. Again, Mr. Hosmer-Henner did note that they attached two cases. Again, those two cases are from outside the jurisdiction and again contain different standards than the controlling standard here in Micon. A Micon decision sets the standard, sets the burden, and we believe we've met our aspects under that burden. Mr. Gruden has failed to meet his burdens under the Micon decision. So again, we would submit that the stay is appropriate and would request that Your Honor grant the motion.
Thank you. So the matter is now submitted. This will be the ruling of the court. I don't find that the defendant here is seeking to state that it's frivolous or that it's dilatory, but in weighing the interest of the plaintiff and being able to move the case along, that's more important to me right now. They did make a good showing that the appeal lacks merits for the reason that the N.F.L. is not getting the benefit of the bargain. That was a contract between Mr. Gruden and a professional sports team. Even though they're a signatory, they're not a party. They just signed in an approval capacity. So I am going to deny the motion, but you of course have the remedy to request a stay from the Supreme Court. And if you get one, again, I won't be offended.
Thank you, Your Honor. And just to be clear, Your Honor entertained at least a temporary stay of perhaps 45 days to give us the time to make that request to the Supreme Court and have that consideration be made.
Your
Your Honor,
response?
Our stipulation remains the same regardless of this court's ruling, so we will agree and provide them with the extension of time to answer until they have the opportunity, assuming they promptly file their motion to the Supreme Court, until the Supreme Court can rule upon that motion.
Include that language in the order so that the defendant is protected.
Yes, Your Honor.
All right, thank you all.
Thank you, Your Honor.
Thank you, Your Honor.